Okay, well, I see a couple people are starting to attend, but we do want to be respectful of your time. Thank you all so much for joining us today to learn about one, the Master of Legal Studies in Cybersecurity and Data Privacy, but maybe more specifically, what the California Privacy Rights Act means for privacy professionals. We will, of course, Brian Ray, who we have with us, and I'll introduce him a little bit more in a second, but we, of course, will talk about that and also talk about the program. So any questions that you have about either as we're going through our presentation, please do not hesitate to either raise your hand, put a question in the chat, or speak if you are able. So I do want to introduce who's with us today. So I'm Julie, excuse me, Julie DiBiasio. I am the director of the Master of Legal Studies for Cybersecurity and Data Privacy. Looking at the list of attendees, I am happy that I have spoken with a couple of you who are interested in the program. Those that I haven't had the pleasure to speak with, I hope I get to in the future. If this presentation inspires you to start this program, we hope it does. But mostly, I know what you are all here for. You are here to hear from Professor Brian Ray. So Professor Brian Ray founded and co-directs our Center for Cybersecurity and Privacy Protection at CSU's College of Law. He also teaches in this program, and I know I embarrass him every time we do these webinars, but every single year, every single semester, truly, the feedback that I get is that Brian's class, he teaches Introduction to American Law in the program, is their favorite. He's an excellent professor, not only with the subject matter in the class, but connecting our students to various career opportunities in the cybersecurity and data privacy space. He is so well connected. So if you do this program, you are in very good hands. Or if you're just here to learn from him today, you are in very good hands. So Brian, I'll stop embarrassing you and I will pass it over to you to talk about our topic for today.
Thanks, Julie, and welcome everybody. As Julie mentioned, we're very pleased to have you. And what we hope to do today is give you a flavor of the kinds of issues that you're going to encounter in this program. And then we'll tell you a little bit more about the program. And this area in particular, state privacy law, is one of the fastest moving, most interesting areas in cybersecurity and privacy. And I say cybersecurity and privacy because, as we'll see, these new laws that are coming on board, including the amended version of California's path-breaking law, include cybersecurity requirements. And so one of the things we emphasize in the program, and the reason our program is particularly valuable, is the kinds of risks that and the requirements that these laws create really drive a lot of what's going on, both on the security side and then in particular on the data privacy side. So let's jump in and talk about the California law to start. So just to give you a little bit of history, California was the first state to create what we now refer to as a comprehensive consumer privacy law. As it stands right now, there is no comprehensive federal consumer privacy law. Instead, data privacy and data security at the federal level are siloed. There are significant requirements, legal requirements in certain areas, especially health and financial services. And then there is a consumer protection regulator called the Federal Trade Commission, which has interpreted its long-standing statute that says nothing about privacy to incorporate as a dimension of consumer protection both data privacy requirements and data security requirements. And under the current leadership, the new chair, who's a former law professor, Lina Khan, they've been even more aggressive in expanding kind of the scope of what they do, but there are limits to what they can do because their statute has certain limitations. Beginning with California in 2018, states have started to fill that gap. And really what's happening in the states, as I'll talk about in a minute, is the US states are following a model developed in Europe under what's called the General Data Protection Regulation, which is implemented and with some variability in the European states that subscribed to the treaty that created those requirements. And California created its first law that didn't completely track the GDPR, as we call it, but did a lot of the same things that the GDPR did, and was really the first US jurisdiction to do this. And so it is in operation right now. The Attorney General in California has brought some of the first cases under it over the last year. And essentially, it provides a set of rights to consumers for things that companies can and cannot do and need to ask permission for with respect to personal information, which is defined in the statute, and covers things that we would deem to be generally to be able to identify us in sensitive ways or in ways that jeopardize our identity or security. Now, California, notwithstanding the fact that it created this path-breaking law and was the first state to do so, amended that law in 2020. And that amended law brings California, as we'll talk about in a little bit, even closer to Europe in terms of adding additional protections, and as well as doing some things that the European statute doesn't do. So I'm going to get to the specifics here in a minute, but one of the other things that the CPRA, the California Privacy Rights Act, which collectively we now still refer to it as the California Consumer Protection Act, because the CPRA was a bill that amended that. But the California law, the amended version, added the creation of a new entity whose job is to flesh out the general legal requirements with more specific regulations. And they're in the process of doing that. They have issued some draft regulations. And so now we've got a very robust, the most robust system for privacy protection in the US, and one that gets California very close to Europe. So let's talk about what the CPRA did and how it changed and really expanded the CCPA. So here's a nice graphic from Bloomberg Law that they put out early on once the CPRA came out. The four basic rights that the California law created with the CCPA is the right to know, the right to delete, the right to opt out, and the right to opt in certain circumstances. So let's walk through those quickly. The right to know simply means you can do what's called a data subject access request and say, hey, what information do you have on me that fits this definition of personal information, or PI? Now, the CPRA expands that to say, okay, not only what do you have on me and what are you doing with it, but adds a new category of sensitive PI, which includes things like biometric information and other things, and also adds the ability to find out not only what do you have and what are you doing with it, what the CCPA focused on how you're selling it. Now we get to find out, or California residents get to find out, are you sharing it and how long are you keeping it for and why? The right to delete, this again comes from Europe, and under the CCPA, any consumer had the right to say, hey, I want you to get rid of this PI that you've collected from me. Now that I found out what, you can see how these intersect, now that I found out what you have. And the CPRA now extends that from not only the information that's within the control of the entity itself, the company itself, but also any information that they shared with third parties, in essence. The right to opt out is one of the core rights in the CCPA. And it basically says, okay, once I find out that you've been collecting information from me, I have the right to say stop. And to stop, in specific, selling the personal information that you collect for me to third parties. And the CPRA now expands, just like the right to know expands to finding out not only who are you selling it to, who are you sharing it with, the CPRA expands it to say, stop sharing my information that you've collected. And then the right to opt in, that's a more specific subset. In certain instances, you're allowed to say, hey, don't do it from the start. And again, the CPRA has expanded that. Now, and then the right to sue and the right to non-discrimination, all over there on the right side of the slide, also pre-existed in the CCPA, although in both the CCPA and the CPRA, they are limited to suing where there's been a data breach. And here is one of the connections between data security, cybersecurity, and data privacy. And the CPRA, again, expands that definition of what would constitute a data breach and when you can sue. And then the right to non-discrimination simply said under the CCPA, hey, if I exercise these rights, you can't discriminate against me in terms of the services you provide. If I tell you to stop selling my information, and now under the CPRA, if I tell you to stop sharing, and the CPRA now also prohibits retaliation not only against consumers, but against employees as well, who now have rights under this that are expanded under the CPRA, and then also expressly permits loyalty cards as an exception, which is one of the big issues that companies had brought up. Now, the new rights under the CPRA is a right to correct. So a right to say, hey, now that I found out what information you have on me, there's something wrong. There's something incorrect about what you've collected about me. And this is similar to the rights you have already under federal law for your credit report. And then the right to limit the use for this special category of sensitive PI. And so this provides more extensive protections that say, all right, you've collected it. Under the CCPA, I could stop you from selling it. Under the CPRA, I can also stop you from sharing it with third parties. Now I can also, even though I gave consent up front for you to collect it, I can, for this narrower category of information, restrict how you actually use it yourself. So much more extensive rights under the CPRA. Okay, here on the slide deck, this is from a nice chart that a law firm put together and that's been reused extensively in blogs. It just gives you a nice summary of some of the details of these rights that I just mapped out. And you can see graphically now, with the blue checks on the right column is the CPRA, how the CPRA has extended things. There are additional protections for minors, although those were already minor protections in the CCPA. This special category of sensitive PI in the CPRA, new agency who's in charge of the regulations. The AG still is in charge of enforcement. And then penalties stay the same. But now you see some additional specifics. A new requirement in certain circumstances that there is built in by design data protection requirements. A new requirement to maintain records of how you're using PI. New requirement for, again, in certain circumstances, what we call a data protection impact analysis, which is a more robust analysis of a proactive analysis around what are you doing and how might this affect the rights of consumers. Notably, unlike Europe, CPRA did not add the requirement that you have a data protection officer. And then it did add storage limitations and data minimizations, i.e. You can't retain for as long and you have to minimize what you're retaining, which is both good for security and good for privacy. Okay, so that in a really quick nutshell is the way in which the California law has evolved. And as you can see from that summary, California already had a range of requirements that required professionals to help companies figure out how do we comply with these, and then to help them comply with them on an ongoing basis. Because those data subject access requests, and now those requests to be able to delete, to be able to correct, to be able to limit the use in certain circumstances, all of that require a lot of compliance work, internal work, some of which is done by lawyers, but some of which are done by what we call compliance professionals, and increasingly a specialized subset of compliance professionals, the top of which are the chief privacy officer, but also there that are privacy specialists within a company. Okay, well, as I mentioned, CCPA and CPRA come on the heels and are largely modeled in many ways on the European law, the General Data Protection Regulation, or GDPR. And this is just another nice quick summary where we can see how the CPRA, in essence, filled in a lot of the gaps, extended California's law to start to do a lot of the things that GDPR already did, including at least one thing that GDPR does not do, these specific links, which is a mechanism for how you exercise these rights to not share and not sell. Notably, as I mentioned in the previous slide, still don't have the requirement of a data protection officer, which is a dedicated role within your company. Doesn't always have to be full-time, but functionally, the extensive requirements that California requires require at least some full-time people who are working on these things. They don't have to have this title as they do in Europe, although a lot of companies are moving in this direction. And then the requirements around cross-border transfers, that is a specific issue in Europe, because of course, within the European system, you're concerned about this up front. California is not concerned about that as much, and states still in the United States still don't tend to have those kinds of requirements. All right, then finally, the last thing I want to mention before I turn it back to Julie to talk about the program, although I'm happy to take questions right here, and I see that I've got one that I'll turn to in just one second. The other phenomenon that we're seeing, as I mentioned at the top of our webinar, a number of other states have already passed laws, at least echoing, if not directly modeled on California's law. And last year we had a number of states, including Ohio's, which is a law that I helped to work on, that have put out legislation that didn't pass. But we already know there's significant legislative activity in 2023, and it's highly likely that we're going to see a cascade of other states following in California's footsteps, but with key differences. And on this chart, which comes from TrustArc, one of the major companies that provides software to help with compliance, we can see when you compare across these different components, that different states are kind of opting to have different configurations. And then more importantly, especially with Colorado's law, we're actually seeing different language that needs to be interpreted. And Colorado already has draft regulations out. And so it's just getting harder and harder to start to comply with all of these different regulations, because first there was GDPR and companies scaled up to do GDPR, and all the companies that did were in pretty good position to comply with CCPA, although again, there were some key differences in how you had to comply, including that button that I mentioned. Virginia, most analysts say if you're complying with CCPA, it's not that hard to comply with Virginia, because largely what Virginia does is exclude some of the specifics that California has. But when it comes to Colorado, there are very key differences, and then Utah and Connecticut as well. There are some key differences where you've got to be very attentive now to what am I doing, and if I'm operating in these jurisdictions, which most even medium-sized organizations, unless you're very, very local, you're going to have consumers from these jurisdictions. There are limits in terms of the amount of activity and or the number of consumers you're serving, which might allow you to exclude yourself from coverage, but you're going to have to think about it. And even that analysis of am I covered is going to take some expertise. Okay, so let me I'm open the floor to questions about this really fast presentation, and I've got one already from Harsha Banavara. In a B2B context, where an organization sells their product to another business, who in turn sells the product to end users, is storing and processing information of the other business information, such as email address, phone numbers, IP address, credit card numbers, and physical address of the business location considered personal data. So it's a complicated question that would require a little bit of follow-up, but from the details you've got in that question, Harsha, if you've got individual information, email address, phone numbers, IP address, certainly credit card numbers of individuals, of consumers, then yes, because now that business when they initially collected that, they were certainly covered if we're talking about individuals, consumers. And by sharing it with another business, even though that sharing is a B2B, they're definitely, or almost certainly, as a lawyer, we know how to caveat until we get concrete, covered under CPRA. Now, the address of the business itself is not considered, would not be within that definition. But certainly if you've got individuals and you're sharing that information, well, but when you've collected it, you've put yourself under the coverage of CPRA, and now you're essentially sharing. And if you're sharing and it's a transaction where you're receiving money as a result of that, then you're selling. So you're hitting that. But if you're just sharing it, even though it's for some shared business purpose, then nonetheless, if it's consumer information, you're going to be covered. Okay. Feel free to pose questions. Raise your hand if you want to talk, or put them in the chat. But I'm going to actually, Julie, if it's all right with you, I'm going to take the next 3 slides and then I'm going to turn it back to you.
Sounds good. Thank you.
So as I mentioned, the point of giving you that rapid survey of California and even faster comparison with GDPR and other states is that's the core of what we do in the Master of Legal Studies in Cybersecurity and Data Privacy. We are a program, a degree that's offered by a law school, but we recognize as we develop these courses, and we have a dedicated certificate for students in the law program who are getting a Juris Doctorate because they want to practice law, that one of the key aspects of this field is whether you're a lawyer, you're on the technology side, or especially if you're in compliance, which is sometimes lawyers, but often non-lawyers who are implementing the requirements of laws across the board, including in privacy and security. You've got to understand the legal side of this. If you're on the technical side, the risks and the technical controls that you're developing are often driven, in some cases even specifically prescribed by legal requirements. And then when there's an incident that occurs, you've got to be able to talk in real time to the lawyers. So there's real demand for this legal expertise. Now, in addition to the legal expertise, as I'll explain in more detail when we get to the curriculum, we also give you a grounding in the technical side. Now, if you're already a cybersecurity technology professional, this will be a review, and we always give folks the opportunity to work with us and try to waive certain requirements and take other courses that we offer within the law school or within Cleveland State generally. But often folks want to come back and kind of do a review. And likewise, we get lawyers in this program who are interested in getting this expertise, and the foundational law courses, we offer the opportunity to waive those, but often folks want to get that review. But regardless of where you're coming from, we're giving you that in-depth legal understanding, and then we're giving you a grounding in the technical side. Now, it's important to emphasize that this is not the degree for someone who knows, hey, I want to go deep on the technical side. I want to become a pen tester. I want to get started, or I'm already an IT professional. And I know I want to go deep on the technical side of security. We'll give you a fantastic grounding, and the legal information that we are going to give you and the skills you'll get are going to help you throughout a career in cybersecurity, whether you're on the technical or the legal side. But we are primarily a legal degree, and compliance is really our sweet spot, or facilitating someone who's on the technical side and wants to advance up to a CISO or sub-CISO level. But if you really want to jump into the technical side, you really should pursue something like a boot camp, a CompTIA, or a SANS certification, because those are really going to move you more directly into the technical side. So as we just saw, the legal side, that's our emphasis. That's the expertise that we really offer. And I just went through it, so I'm not gonna repeat that. But there are a whole host of other laws that I didn't touch on, based in security, based in healthcare, based in financial services, and other areas. Okay, now the curriculum in short, the way the program is structured, it's 10 courses across 5 semesters, part-time, asynchronous. with synchronous components for every course. So you get to know your instructor, get to know your colleagues in the program. Right now, we have a dedicated set of 10 courses. This is not the sequence you will always take them in, because we combine you with current students in the courses, so in the program, so you get to know other folks as you move along. And you'll also have often law students and other students from CSU grad programs in these courses as well, although predominantly courses from this, or are students from this program. Introduction to American Law is the course that I teach that Julie mentioned. It is the overview of American law. It's really a kind of boot camp for law, focused on the areas you'll encounter as a security and privacy professional. Legal writing then pairs with that and goes a little bit deeper into the mechanics of consuming and producing legal documents, again, with a focus on cybersecurity and privacy. It's taught by a lawyer who graduated from us years ago and is now in-house counsel with State Farm, and she's an incident responder, so she's deeply immersed in these areas. Cybersecurity 1 and 2 then are our foundational technical courses. The third technical course, if you look on the far right side, is the technical capstone. Those are the 3 technical components you get in this course. We throw you a little bit in the deep end, but we hold your hand throughout. Spence Witten, who is really our resident technical expert, works closely with me to counsel students on careers in this area. He pushes you hard, but helps you along the way in cybersecurity 1. You'll do labs. You'll learn about what it looks like from the technical side and how the technology of cybersecurity works. Cybersecurity 2 then pivots. It's still a technical course, but it's more about the policy and about building controls that will fulfill the requirements of the legal requirements that you'll start to learn along the way. Privacy law and management then is the foundational upper level law course. It's a survey of all of the major privacy and security laws with a focus on the US, but 2 modules that go through the European laws. Most of the other international laws in this area are even more directly modeled on Europe, with the exception of China in particular. China has its own regime. We don't yet cover that directly, although working on adding, or we're considering adding an international law course that would go deeper into that, an international privacy cybersecurity law course. Corporate compliance 1 and 2 then pull the lens back into, as I mentioned, our core competency really is in compliance. And so it talks about generally how compliance programs work, the history of them, and how privacy and security fit within those programs, and really what a compliance officer and people working in the compliance roles do. HIPAA and privacy is our other second upper level legal class. HIPAA is the major healthcare law in this area. And the reason we do a deep dive on HIPAA is because most of the other federal legislation is modeled on HIPAA. And if you understand HIPAA, you really can easily get up to speed on the financial services regulations, as well as state laws. Then cyber law pivots out into national security, criminal law, as well as international law. And that course is taught by a professor at the United States Air Force Academy, who's former member of Cyber Command. Really lucky to have him teaching these aspects. And then, as I mentioned, the technical capstone goes deeper and really dovetails with cybersecurity 1. Spence Witten teaches that one as well. You'll use the Ohio Cyber Range, and it's mapped to about 2/3 of what's called the Certified Ethical Hacker certification. Okay, so that's our curriculum. One last thing I want to mention before I hand it back to Julie in terms of the program outcomes is that along the way, we are going to emphasize that you should go after certain industry certifications. Several of our courses, privacy law and management and technical capstone in particular, give you information that maps to those certifications, but it's much deeper set of information, and it's more practically focused around how do you use these things as a professional. The certifications then are essentially cram tests that give you objective badges that industry values. And the main one that maps to privacy law and management is the IAPP's Certified Information Privacy Professional. As then I mentioned, technical capstone, it's the Certified Ethical Hacker. And then there are a few others along the way, depending on whether you're focused on security or privacy compliance that we'll talk about. And it's just part of the game. The degree is going to give you a depth of knowledge that will be valuable across your career. But it's important, especially if you're trying to get an entry-level job, to get some of these badges that demonstrate that you functionally that you've crammed for these very specific tests. We'll talk more about that when you get into the program, and part of the advising we do is pointing you in those directions and help you figure out how to prepare for them. Okay, actually, I'll take this slide. I've already mentioned this, but it's what we call the 360-degree view of cybersecurity and data privacy with an emphasis on the legal side. You'll learn in a really practically focused way to use the skills that you're getting. And again, we consider it a degree that's valuable for folks across the spectrum, but it's not really the degree for someone who wants to get an entry-level job who doesn't have technology experience already on the technical side. If you're in technology roles, it's a great way to demonstrate, hey, I'm going deep on cyber. I'm expanding my ability to take a leadership strategic role. And then on the compliance side, that's really our sweet spot. All right, now officially back to you, Julie. Although I'm happy to take questions about the program as well.
There is one question actually.
Oh, I missed it.
From Melody. What are the prerequisites for this program?
No, it's a great question. The only formal prerequisite is a BA. If you are, our official requirement is, remind me, Julie, is it a 3.0 or 3.5?
3.0.
Is a 3.0. Although if you're lower than that, then if you're close to graduation from undergrad, we'll require you to have a GRE score or an LSAT if you happen to have taken it. But if you've got experience, we'll take that into account. And if your undergraduate, in other words, your undergraduate GPA becomes less important the more experience you have. And so if you don't have a technical background, but you want to get into this, don't worry. Like the Cyber 1 and 2 and the technical capstone were built for people with no technical background. It's not that they're not challenging, they absolutely are. But we keep the numbers small, and so we'll get you up to speed on those. Yeah, if you've got a BA and an MBA, that's fine, absolutely. As I said before, we have folks who've got master's degree in technical side. We even have folks who have gotten a JD. It is structured to be part-time, Harsha. It's possible, so it's 2 courses, 6 credits a semester. It's part-time in the sense that it's 2 courses a semester, 6 credits, but to get through in the year and a half, you got to take those courses. You take it in wherever you start. You take it every semester, including summer. You can take a step off that sequence. It'll just take longer to complete it. But we encourage folks to try to stay on it, because especially if you're a working professional, we just know from experience and from the industry's experience, often people have a hard time getting sort of back on the back on the sequence, because it is challenging to do it as a professional, but it's built for that. So there's flexibility in the courses itself. Every course, it's a week-long module. You've got to complete the materials within that week, and there are deadlines for the main discussion posts and their assignments sometimes. But otherwise, you have the whole week to get them done. But it's important to stay, and you're required really to stay in sequence on that. About, I would say, over 90% of the students that we have in the program now and have completed it were full-time working professionals.
Yeah, and I do want to mention, just in case it wasn't clear, this is 100% online, this program, and it's asynchronous. So as Brian said, when you're completing those modules, you do it on your own time by the deadlines. So it works really, really well for our working professionals. All right, so if this presentation or what you heard about the program today inspired you to learn more and you want to enroll in this program, our next application deadline is April 21st, and that is for our summer 2023 cohort, which begins on May 8th. So also, as Brian mentioned, we enroll students every single semester, and you will take courses every single semester for a total of 5 semesters. If you do the program on a part-time basis, which we recommend, it's a total of 5 semesters. So again, just as a reminder, April 21st is the deadline. May 8th is the start date for the summer semester cohort. The application is open on our webpage, onlinelaw.csuohio.edu. We strongly encourage you to reach out to either myself or Brian with any questions you have about whether you're a good fit for this program, if it makes sense given your background and what your ultimate career goals are. If you have any questions about if you'd be qualified because of your undergraduate GPA, we really want to talk to you about that and make sure it is a good fit. Brian, is there anything else you'd like to add?
That's it. As Julie said, please feel free to reach out. We're happy to talk to you and again, kind of assess where you're at and if this is the right program for you. And also possible ways to configure the program if you already have experience in either the technical side of security or in the legal compliance side.
Yeah, and here's our contact information. That email goes to both Brian and I. So if you have any additional questions, please email us, and depending on what makes sense, Brian or I, or maybe both of us, will reach back out to you. But we thank you so much for being here and listening to our presentation. We hope you have a great rest of the day, and we really hope to talk to you soon.
Take care. Thanks, everybody.
Bye-bye.